I do want to talk about making sure you get this into court, because states, it's one thing to do discovery, it's another thing to actually make sure if you're going to try the case, or at least set the case up for trial so you can then leverage your settlement value, you got to make sure that you're going to be able to get the goods into the courtroom. And there's a whole different standard between, as you know, discovery and evidence. And first practice point is do it early if you can, because you may run into trial deadlines and discovery cutoffs, and trial judges will say, I'm not going to extend discovery for this, et cetera, et cetera. I just want to give one chronology, which I think is helpful. We had a 2007 accident in New York, and it was a freight elevator hit the individual on the top of his head, basically because he wasn't looking where he was going. Ended up, he was a young man, 2007 incident, ended up getting arthro knee surgery, and he filed a note of issue in New York, which means he's ready for trial at the end of 2010. Well, we continue to do social media searches. We use Magna's Claim Scout service, and we kept updating it. So lo and behold, October 1, 2012, we have a YouTube video of this fellow who's going for his PhD, and he is part of a project that made this little robot that he took out onto fairs, and he's introducing himself at this fair, and he's demonstrating how it's going. He's moving very freely, and it looks like he's having a regular, normal physical amount of activity. Well, then we have to make sure we get it into evidence. So in New York, it gets a little tricky, and here you may have to, you're going to have to give up some of the element of surprise. We have to follow pretty much a notice to admit kind of a rule, and I did a little chronology where one of my local counsel actually used something that he had seen other people do, where he said he would file a notice of intention to introduce video at trial. And this was after the second notice of trial, where we still hadn't been called out. And that was in January 2013. In February, we followed up with the notice to admit. If that notice to admit is not denied within 30 days, it's deemed admitted. So that passed. We knew we were in. We go to trial on the first day of trial. Now, the plaintiff knows this is coming. And we had a $1.2 million demand on this case by the plaintiff, who never moved for the entire 6 years of litigation. And on the first day of trial in 2013, we settled the case for $150,000. We still had some issues on liability. We were defending the building owner. So after the incident, the building owner started to control the freight elevator from a manned security desk. So that was an issue as well, and that could have hurt us on liability. We had a known injury, so it was a very reasonable value of the settlement, but a good chunk of that money went to doing the social media and making sure it got into trial.